Welcome to EU Privacy for All, Session 36 on GDPR, Codes of Conduct, Article 38. European Parliament made some proposals, some of which were not retained. For instance, the fact that supervisory authorities themselves could adopt code of conduct and draw them, or the respect for consumer rights. On its side, most of EU Council's proposals were retained, such as the fact that European Data Protection Board should be added to Member States' supervisory authorities and Commission to encourage the drawing up of codes of conduct, or the necessity to take into account the specific needs of micro, small and medium-sized enterprises. All the topics that could be framed by code of conduct as suggested by the Council were retained, such as legitimate interest, solemnization, child consent, responsibility, privacy by default, by design and security, and personal data breaches. It was also validated that code of conduct may be adhered to by controllers or processors that are not subject to this regulation, in order to demonstrate they provide appropriate safeguards through binding and enforceable commitments. Reference to a body that is framed in Article 38A to carry out mandatory monitoring of compliance of the code was also retained. Finally, the fact that registers would be established by both supervisory authorities and EDPB was laid down in the final draft. Article 38 mentions that Member States supervisory authorities, EDPB and Commission shall encourage the drawing up of codes of conduct in various data processing sectors and taking into account specific needs of micro, small and medium-sized enterprises. Associations and other bodies representing categories of controllers or processors are the ones habilitated to prepare code of conduct, to amend or to extend such codes. They may frame some topics such as fair and transparent data processing, legitimate interest pursued by the controller, collection of data, pseudonymization, information of data subjects or of the public, exercise of the rights of data subject, children and the way to collect the consent of the holder of parental responsibility over the child, measures and procedures regarding responsibility, privacy by default and by design, and security, but also notification of data breaches, transfer, and out-of-court proceedings. Additionally, controllers and processors that are not subject to the regulation can adhere to the code, because they will be demonstrating doing so that they adopt appropriate safeguards through binding and enforceable commitments. Mechanisms to frame the mandatory monitoring of compliance through a body that will be determined in Article 38A, next session, shall be specified. The associations and other bodies drafting the code shall submit this code to the supervisory authority that will give an opinion and, in the end, potentially validate the code. In such a case, if approved, and if the code does not relate to the processing activities in several member states, the supervisory authority has the obligation to register and publish the code. In cases in which the processing activities take place in several member states, EDPB is competent and shall give an opinion regarding the compliance with the regulation. In such a case, it shall submit its opinion to the Commission. The Commission, on its side, have to adopt, if necessary, implementing acts regarding general validity within the Union. The Commission shall also ensure appropriate publicity of the approved codes. And finally, as for supervisory authorities, the EDPB has the obligation to keep a register of all code of conducts available. Key provisions in the GDPR are Recital 76 and 76A, laying down that those codes are supposed to facilitate the effective application of the regulation in different sectors and most of all to target micro, small and medium enterprises. This would be a way to, and I quote, calibrate the obligations of controllers and processors, a notion that is still to be defined. Those associations and other bodies representing categories of controllers or processors should consult with relevant stakeholders, including data subjects where feasible. Other recitals lay down guidance on the implementation of appropriate measures that can be provided by approved code of conducts, the fact that implementing acts will frame those, the adherence to the code that may be used as an element to demonstrate compliance, and the specific case of assessing the impact of the processing operations in the frame of a data protection impact assessment regarding notably compliance with approved codes. Other articles stress the fact that the drafting of code of conduct shall be encouraged. The approval of draft code of conducts is an obligation for each supervisory authority, for EDPB also, and the adherence to approved code of conducts could be assessed in the frame of imposing and defining the amount of an administrative fine. Currently, the directive lays down that Member States and the Commission shall encourage the drawing up of codes of conduct. Member States shall make provision for trade associations and other bodies representing other categories of controllers only to be able to submit them to the opinion of the national authority. The drafts, if they fit the expectations of the national authority, shall imply that this authority seeks the views of data subjects or their representative. Moreover, draft community codes submitted to Working Party 29, if it sees fit, also require to seek the views of data subjects or of their representative. And, as in GDPR, Commission may ensure appropriate publicity for the codes. What should accountable data controllers and processors get prepared for? First, they will have to use associations and other bodies in order to prepare codes of conduct. Second, they will have to bear in mind that EU Commission, EDPB, Member States and supervisory authorities will specifically check specific needs of micro, small and medium-sized enterprises. They will have to focus on different topics such as fair and transparent processing, legitimate interest, collection of data, pseudonymization, information of data subjects, rights of data subject, children rights and collection of the parental consent, responsibility of the controller, privacy by default and by design, but also security, data breaches, transfers and out-of-court proceedings. Also, those codes may be adhered to by controllers or processors that are not subject to this regulation. They shall contain mechanisms enabling a body, Session 37, to carry out the mandatory monitoring of compliance to the code. Submission of the code could be to a national data protection authority or to the EDPB for activities that are taking place in different countries. The national authorities and the EDPB will have to update a register related to the Code of Conduct validated, and EU Commission will have to adopt on its side implementing acts and appropriate publicity. The remaining question now is about the necessity to consult data subjects and a possible approval of Code of Conducts by national supervisory authority or by the EDPB. Let's remind that so far, Working Party 29 only validated one.